So my colleague has covered why we think Canadian administrative law has evolved to the point of recognizing a principle of deference as a core component of respect for the democratic creation of self-contained autonomous administrative decision-making schemes.
A little louder, please.
Sure.
Thank you.
I'm going to discuss now how this institutional model fits within the Canadian constitutional structure. I agree entirely with the proposition that was put to you that legislative choices and institutional design must comply with our constitutional design, and that there are indeed two pillars underlying the underlying judicial review: legislative intent and the rule of law. The question for us at this point is therefore, when does the rule of law, which is, of course, the other twin pillar underlying judicial review, require courts to definitively decide what the law means? In other words, what are the constitutional imperatives? Because I do believe that there are some. So I'm going to begin with the importance of articulating a robust theory of the rule of law, and then go on to discuss its implications for true questions of jurisdiction and the categories that we argue, and in one case I argue, require courts to have the final say. I think one of the problems with Dunsmuir is that while it articulated the rule of law as the twin foundational principle underlying judicial review along with legislative intent, it didn't really fully account for what the rule of law means. The majority notes that the rule of law is affirmed by ensuring courts have the final say on the jurisdictional limits of a tribunal's authority, and this definition fails to account for the full scope of judicial review that has evolved post-QP, and doesn't account for all the facets of the rule of law as a constitutional principle. Now, I'm very mindful that when we use the term rule of law, we have to be careful. It's one of those concepts that can mean all things to all people, and it can't be so broad as to serve as a justification for basically any type of intervention on questions of law. But it is nonetheless broader than what was presented in Dunsmuir, and if we want the next framework of judicial review to last longer than 10 years, we have to come to a common understanding of what the rule of law means. So we chose to ground the definition in this court's jurisprudence, and we think that's
it must be fair to the authors of Dunsmuir. What was said is that the standard of review will be a contextual decision. However, for rule of law purposes, 4 categories are clear and will always give rise to correctness. It didn't say those are the only circumstances where rule of law will give rise to correctness.
Yes, absolutely, and I think one of the issues there is that the categories enunciated in Dunsmuir weren't specifically connected to individualized rule of law principles, and that's what we propose to do in our approach. So we look at the court's jurisprudence and find 3 components of the rule of law. First, that there must be a system of laws, which relates to the principle of intelligibility. Second, that all state action must be authorized by law, which that delegated authority must find its source in law, which is legality reconceived as my colleague presented. And third, that there must be equality before the law in the sense that the law applies to everyone, which is the value of consistency. In addition, to enforce these principles, there must be a basic level of access to courts. And so these, combined with Section 96 of the Constitution Act, means there is a special role for the judiciary in upholding the rule of law that can't be ousted by statute, implication, or institutional design. But this means that we must have judicial review, i.e. why a privative clause can never oust judicial review entirely on any question, even a question of fact, but only in a few instances does it compel a particular standard of review. So the question is when. First, and perhaps somewhat counterintuitively, I think the first question is when doesn't it? And that's our submission on the category of true questions of jurisdiction. And I know you asked this question to my colleague already, and he began with the answer, and I'll complete those submissions. In our view, the concept of legality can be controlled through meaningful reasonableness review. And I think it's telling that in 10 years, not a single judge of this court has been able to provide a lasting and comprehensive definition of what a true question of jurisdiction, which is some concept of jurisdiction other than the daily fare of statutory interpretation that administrative decision makers do, that would constitutionally mandate a standard of correctness. And the fact that we went through the history of the jurisprudence, not for the sake of providing a summary, but because it shows that the struggle to delineate the concept of jurisdiction has eluded the jurisprudence for decades. Just prior to Dunsmuir, we had come to accept in Pushpanathan that the term was just a shorthand for questions on which the legislature intended that a standard of correctness apply after the, quote, standard of review analysis. And as a conceptual matter, I think it's time to come to terms with the fact that there is no constitutional subset of true questions of jurisdiction, because all questions are about the limits of authority in one way or another. My colleague for CPIC presented you an example. He said, well, I can think of an example. What about interpreting the phrase ordinary course of trade? That's got nothing to do with jurisdiction. But if the decision maker interprets trade to mean banking, then the decision maker will be exercising jurisdiction over a subject matter not conferred to it. So the distinction just breaks down.
Well, I'm going to give you an example from Monty Python. The fellow goes into the office and says, I want a cat license.
Mm-hmm.
And the guy behind the wicket says, no, this is the dog licensing board, not the cat licensing board. And the guy holds up a dog license with the word dog crossed out and cat written in crayon. The true question of jurisdiction is whether that officer can grant a cat license. The question of whether the license is properly issued, which is not the jurisdictional question, and which I would show deference in, is whether you properly issue the license by crossing out dog and writing in cat.
Well, I mean, the question is, what's the meaning of dog? It's like that's the question, and it's no different than what's the meaning of costs in a statute.
Responses to that, two reasonable responses. Yes, in the case it's a dog, and in no, it's reasonable to think it's a cat.
Well, again, that depends, right? What is a dog a multi-factor test that can lead to different answers, or is there only one answer?
I understood the submissions to be not that there is no such thing as a true question of jurisdiction, but that it's not a useful paradigm in administrative, in judicial review.
That's absolutely right. It's not that jurisdiction as a concept doesn't exist. It's that there is no subset within that category of jurisdictional questions that for constitutional purposes requires a standard of review of correctness. The reality is we have been reviewing the vast majority of jurisdictional questions on a standard of reasonableness since CUPE, and there is no constitutional imperative to carve out a subset of those questions, call them true questions of jurisdiction, and apply a correctness standard. And that's why
do you have no difficulty then with the idea that an administrative delegate's decision as to the bounds of its own power is subject to deference by courts?
I think that's what we've been doing since CUPE. The cases on costs, to me, are the best examples of that. This court has consistently held that whether a statutory delegate has the authority to award costs is not a true question of jurisdiction. What else are we asking? They're both interpreting the scope of the word costs and determining whether they have the authority to issue a particular remedy.
That's remedial authority. That's remedial authority as opposed to the scope of jurisdiction, which is the timber cutting board, or whatever we heard reference to before. Can it deal with aviation? That's the scope of jurisdiction.
But that's, again, it's a question about interpreting the scope of timber cutting, and if the delegate interprets timber cutting to mean aviation, well, it's an unreasonable interpretation of the definition of a term that is within the core of its mandate to interpret. So I just don't think this leads us anywhere, and I think a proper, meaningful reasonableness review controls for this adequately from a constitutional perspective.
Doctor, what is so wrong for a question like that? I'm not going to call this a true question of jurisdiction. I would say a question of statutory interpretation about the power of a decision maker to issue a remedy or not, for instance. What is so wrong? What principle will I breach if I say for those responses it will be reviewed under a correctness standard?
There's nothing wrong with that, Justice Cote, but what we're saying is that there's no constitutional requirement to do it that way. No one in front of the court, nobody has come in front of the court, not advocates for the rule of law, not Cambridge, no one has come to say there is a constitutional imperative to never give deference on question of law. Everybody acknowledges that even the question that you raise, the legislature can give deference. So what we're talking about here is a question of paradigms, it's a question of starting points, it's a question of when can we infer that the legislature has intended that. And what we propose is that it's a much more sound approach to view deference as being a necessary consequence of the creation of statutory delegates, as opposed to trying to go through each individual statute and trying to discern legislative intent on 6 different questions within the statute, 3 being on correctness, 3 being on reasonableness. I don't think that's a meaningful search for legislative intent, and that's always what we're looking for.
So you've heard a lot of expressions of concern that we don't upset much of our jurisprudence. Would this upset curiae?
I don't think this upsets curiae because I don't think curiae requires a particular standard of review. I read curiae the same way Justice Abella does, which is that it constitutionally guarantees judicial review, but that it doesn't prescribe a particular standard of review. And that as long as we can control jurisdictional questions through a standard of reasonableness, we're not doing violence to the Constitution. So I don't think it overrules curiae. So when does the Constitution require non-deferential review? We say there are three on which we agree, and one which I say needs to be kept, which is the question of general importance to the legal system. So I'll begin first with constitutional questions. Obviously, the principle of the rule of law, twinned with the principle of constitutionalism, tells us that the Constitution, as the supreme law of Canada, the law to which all other laws and government action must conform, requires a consistent meaning. So in a constitutional democracy, courts are the guardian of the Constitution. And there's never been an issue accepting this proposition when it comes to questions regarding the division of powers. But there seems to be, for some reason, another approach where the Charter is concerned, and yet the Charter is no less part of the Constitution. In our view, there needs to be a uniform approach consistent with the principle of constitutionalism to constitutional questions, which means that
Can you say that a judge's decision does not reflect charter rights?
You can. There was a recent example of that in Quebec, actually, with a decision of a judge preventing a litigant from wearing a hijab in the courtroom, and the Quebec Court of Appeal determined that that decision breached charter rights.
Her charter rights, but it was her rights. But I'm talking about the review of the decision itself. Can you have a kind of slate analysis of a judicial decision where the judge bears the onus of justifying his or her own decision? I'm just trying to see how, if it's an independent adjudicative body, why, which is a parallel system with the courts and in charge of its own legality, why you would treat it differently than you would a judge's decision.
Well, I mean, I think in this context, what you have is the government who delegates power to the statutory delegate that comes and justifies the decision. And so the government is present in the context of a judicial review.
No, the legislature delegates the power. The government
The legislature,
or
right.
some other entity exercises it.
But I mean, in this case, it's the minister who's coming before you and who needs to justify the decision of the statutory delegate.
So it's a different approach from judicial review, generally where the onus is on the person complaining about the decision.
Because what we're talking about are charter rights, and because the principle underlying the charter is that the breach can only be justified if the government can justify it. It's built into the very nature of the charter. So I'll only speak briefly about competing jurisdictional lines because there hasn't really been much disagreement on that. But it leads me into my next category, which is the persistent discord leading to legal incoherence. Justice Abella, you raised the question of how often does this really happen on the persistent discord, and do we even really need a separate category? I mean, you could, in theory, say that about competing jurisdictional lines. There hasn't, as far as I know, been a clear case of this since Dunsmuir, but we know the category exists, and we readily accept that courts need to step in and settle those disputes of competing lines, jurisdictional lines. So I'm going to move on to persistent discord leading to legal incoherence because I think that this is one on which there are more questions and perhaps a bit more debate, the door number one, door number two problem evoked by Justice Rowe. We defined it as lingering disagreement on a matter of statutory interpretation where it's clear that the statute can only bear one meaning. The Attorney General of Canada says this has never been a category, and it all goes back to Domtar. And Justice Gaston, to answer your question, what does this mean for our previous jurisprudence? I think that accepting this as a category does require revisiting Domtar and acknowledging that there is an error in Domtar. And in our view, the error is the following.
And Wilson.
And Wilson. Although Wilson was essentially decided on the basis that there was only one reasonable interpretation of the statute, although I fully acknowledge that Wilson adopts the reasoning in Domtar.
But we had that question of the so-called persistent discord in Wilson, and the majority said that there was just a handful of contrary interpretations.
Right.
So what does it take in your submissions to have a persistent discord?
So the Chief Justice will permit me to continue. Okay, thank
All the
you.
time, but much more time if you want.
Go
So,
for it.
I'm just going to answer in two parts. First is where I see the issue with Domtar. Domtar is premised on the idea that there are a bunch of conflicting values on a level playing field, and that decision-making autonomy will never give way to rule of law imperatives. Justice Louis-Dubé says we've got basically several contending values: expertise and effectiveness, curial deference, consistency and predictability, and then we have the rule of law on the other. And she asks whether the principles underlying curial deference should ever give way to other imperatives, and says that the answer is no. If we take the rule of law as a constitutional imperative seriously, the answer can't always be no. The rule of law will trump in certain circumstances, and the question, of course, is when, to go to your question, Justice Cote.
But if you look at what judges do, I mean, it's sometimes very difficult when you've got 50 judges on a court to get consistency. Courts of appeal have a mechanism for trying to resolve their own discord, and so do tribunals. So why would we create, how do we step out of the modality that tribunals are specialized in their own fields and broker something which the tribunals can do on their own and do on their own?
Well, and part of our approach is taking into account whether there is indeed an internal mechanism for resolving such issues. But I think it would be wrong to assume that there is always an internal mechanism for resolving such issues. As the dissenting judges pointed out in Wilson, like the labor adjudicators in the present case, they didn't have an institutional umbrella under which the issue could be debated openly and a consensus position could emerge. So I propose that there are three factors that need to be taken into account. One is the proportion of differing decisions considered as part of the overall decision-making of the tribunal. If you have a tribunal or decision maker that's, an instance that's rendered 10 decisions on an issue and it goes 5-5, then 5 is enough. If it's 1,000 decisions and there are only 5, then perhaps it's not enough. But it's not just a numbers game. It's proportionate. It's whether it spans a long time period and whether indeed there is an internal mechanism for resolving such issues. So
The voir dire. I mean, Mike, I can see this as being the next battleground for the next decade. What is a persistent discord, and how many decisions are there? What's it about? What processes do they have? So here's my question. Can we address the same problem in a different way that doesn't undermine your basic premise? So when you're looking at reasonableness, isn't one of the things that's part of the context how that decision maker has decided this kind of issue in other cases?
So I take that point, and I did think about this a lot. Why can't we just deal with this through reasonableness review? And I think if we do that, we're going to be doing violence to the principle of reasonableness. We're essentially going to apply disguised correctness to settle the controversy. And in my view, it's actually more respectful of decision-making autonomy to acknowledge that we're resolving the discord for a constitutional rule of law reason that trumps deference, as opposed to...
Does that mean you're saying it's not a legitimate context? It's not legitimate as context? I mean, we had the conversation earlier with Maître Jutras.
It's legitimate, but I just don't think that it's always going to lead you to the position where there's only one reasonable answer. I don't think always a divergent decision is always going to be unreasonable. That can't be the case, that divergent interpretations, one of them is always going to be unreasonable. That underlines the very premise of deference on questions of law, that there can indeed be more than one reasonable answer.
Can I take you to the rule of law rationale that you're advancing? The implication of that is, since it doesn't come under legislative intent, where there are different positions taken by adjudicators or decision makers in a tribunal or body, the rule of law is offended. What's the implication of that for courts, where you have lots of judges going in different ways? Are we to say that the rule of law is offended because there are so many different positions and the Court of Appeal is obliged to step in every time they see it? I'm comparing, obviously, the two coexistent and equally effective adjudicators, courts and tribunals.
Yeah, and absolutely, I take your point, which is why we say it's not just a matter of where our position departs from the dissenting judges in Wilson to say that one is not enough. We can't expect perfection, and we absolutely live in a system where some disagreement persists. I'm sure I could find different lines of jurisprudence in the Cour du Québec, in the Quebec Superior Court, that haven't been resolved by the Quebec Court of Appeal. In a judicial system, of course, there is always that possibility available to settle the dispute. It doesn't always happen, and we live with that. But what we're talking about here are situations in which the dispute the discord persists to the point of essentially having a citizen subject to the same law. On one day they can dismiss an employee for cause, on the second day they can't, and there not being a way to settle the controversy.
So it's another possible route, because I think we're all troubled by the idea of persistent, inconsistent decisions. But is another possible route to say to the review, there have been inconsistent decisions, you go and you fix it?
To the extent that you can do that, but that's not always a possibility. I mean, what would be where are you going to send it back to be fixed in the Wilson scenario? It lacks that overarching institutional structure. So to the extent that you can do that, and that we absolutely say that where a tribunal has the ability to resolve these types of lingering disagreements itself, courts should absolutely defer to the tribunal solution.
Most of the times they're tribunals, there's institutions. I mean, labor arbitrators are the one example I'm thinking of, and everyone here has argued that should be where we give the most deference.
But again, that's why I'm saying this. We can't think of this as undermining deference. We have to think of it as a situation where another value trumps. Right? We're not saying we're not going to defer because they're not reasonable decision makers. They're not decision makers rendering decisions in a specialized regime. What we're saying is, at a certain point, there's another value that trumps, and the courts are the only ones that can step in to fix it in certain cases. And where the courts are the only ones who can step in to fix it, they have to fulfill their role.
I don't think we should be apologizing for anything, and I don't think we should be looking too hard. I analogize this perhaps wrongly, but in the criminal context, one judge says a conditional sentence is available, another judge says it's not, and if you get in front of that judge, you don't get that opportunity, and if you get in front of this judge, you do. And that's an inequality of the law that smacks of, it just goes against the rule of law. So I wouldn't be too concerned about how many times this has to happen. If it happens once, it's too many, frankly. Yeah, I know you'd like that, Justice Abella, but but I'm just saying, I don't think we should be sitting here apologizing for something that is on its face just completely contrary to equality and the rule of law. It can't be you have a system of law that says if you get Judge X, you get this, or Tribunal Member X, you get this, and if you go to Tribunal Y member, it's not available for you. That just can't be.
I agree with that, and I think it goes back to the point that it's kind of underlines our framework, which is the point of legitimacy. And administrative decision-making loses its legitimacy when these types of discords persist. And it's exactly about, it's actually complementary to maintaining the legitimacy, and as opposed to undermining administrative decision makers to sort these things out when they can't be sorted out through the normal mechanisms of the administrative body.
Other points to cover?
I do. So the last one is questions of central importance. I argue that we need to maintain this category, whereas my colleague would eliminate it. And in my view, the constitutional imperative for this category is grounded in both the rule of law pillars of intelligibility and equality before the law. Justices Bastarache and Lavelle explained in Dunsmuir that there will be questions that make up the basic fabric of our legal order that, because of their impact on the administration of justice as a whole, require uniform and consistent answers. I think once the rationale for this category is properly considered and consistent with the framework that we've proposed, it becomes clear that expertise really has no role to play here. I think the case of Saguenay is a case in point, the state duty of religious neutrality. It was not because it was outside the Quebec Human Rights Tribunal's expertise. It's because it's absolutely a question of fundamental importance that required a definitive answer. So
there's the question that arises by this diverging views that you have on that category or exception. I guess we'll have to figure out how to call these. What will happen? What will we be opening with a category of that sort without the current other basis of expertise? That's my first question. And the second question, which I understand is more the position of the other amicus. If we say that there is no such thing anymore of question of central importance, what will happen to the Calgary, Shanghai, Saguenay of this world?
So
Will they be reviewed on a differential standard no matter what?
so
Because these three examples that I gave are, if my memory served me well, the only three in our jurisprudence that have used this question of central importance. And if we eliminate it, what will happen to those kind of questions?
So those are the three examples post-Dunsmuir. There were other examples pre-Dunsmuir, but post-Dunsmuir, those are the only ones. I think what will happen to this category if we eliminate expertise? I don't think a lot, frankly, because we're talking about a category in which it's questions of central importance to the legal system as a whole that strike fundamentally at the heart of the administration of justice. So I'm not arguing here for a broad notion of questions that are just generally important to the individual, or questions that are just it's not so broad as that. It's really things that strike at the legal system in its operation, which are things like the state's duty of religious neutrality. They are things like solicitor-client privilege, parliamentary privilege. I would probably add litigation privilege in there, but it would obviously have to be determined at another day. And to answer your second question,
You just stick with the first. The question is not just central importance. Your position is that we don't need the second Dunsmuir component, which is
expertise. Because in our framework, expertise is not the basis.
Okay, so
for
that
reference
is
anymore.
what you're answering. You don't need both components.
You don't need both components, and it would be inconsistent with our framework to maintain that expertise component, because in our suggestion, that in our framework, this expertise has proven to be a very unhelpful basis on which to justify deference, because courts are always going to be the experts in interpreting the law, and so it leads us nowhere. Justice Karakatsanis, I'm sorry, were you? No, okay.
But it did lead us somewhere in Normand. I mean, the question of issue estoppel came up. It does confine the categories.
It came up in QP pre-Dunsmuir. There were questions, basic common law notions like res judicata, for example. But I think the second question that you asked, Justice Gascon, about what would happen to these notions, to me it's quite concerning what would happen to these notions, because it's not because questions are of central importance to the legal system that they can only have one answer or one reasonable answer. It's that they need an answer. And solicitor-client privilege, I guess because that's my daily fare as a lawyer, is to me the example par excellence. If I have a client who comes into my office and says, I've done something, I may be subject to civil proceedings, criminal proceedings, and regulatory proceedings, I need to be able to say, tell me everything. I can't say, well, tell me everything, but one of the regulators might interpret privilege in a different fashion. It just doesn't work. So that's one question where it's obvious. Parliamentary privilege, again, it's obvious. Parliament can't function if its privilege is going to be protected in different ways in different institutional settings. So even though I think these types of questions will be rare, I nonetheless think that it's absolutely fundamental that we maintain this category if we're going to have a proper and robust rule of law framework to accompany the principle of deference that we've proposed.
Now, I hear your answer. I just want to have a proper understanding. If it is not there, then your answer, or the answer of the Amici as a group, is that those questions would be resolved under a robust reasonableness review.
Yes, which I don't think is sufficient.
You don't think it's the right way, sorry, but I understand that there's another view.
Yes, absolutely, and the view is exposed in the factum that the other categories are enough of a control, and that this would be.
I don't want to not to look serious. Would you call this a persistent discord? With the under Amicus?
I'm going to move on to my conclusion.
Sorry, just before you move on, could I ask you a couple of things? Is this list that you've categories or whatever, are you putting that to us as a closed list, that's it? I mean, or...
I would never do that, because I don't think that's how the law works. I don't think that, I can't think of every possible instance in which a compelling argument can be made for a rule of law requirement to have a correctness review. These are the ones that we've identified at this time that we believe are consistent with the court's jurisprudence and with the concerns that are raised in the context of the judicial review framework. But I don't believe the law is ever definitive and fully settled for all time.
Thank you. And one other question. Segregation.
Mm-hmm.
Segmentation, not segregation.
There's no persistent discord on segregation.
I'm going to segregate me from this body, but yeah, segmentation. Do you have any comments about that?
Well, I mean, I think segmentation with respect to the correctness categories that we've identified is inevitable. But otherwise, I don't think that there's any segmentation involved. I think actually segmentation is one of the problems with the highly contextualized approaches to judicial review that some parties and interveners propose, is that you would essentially be looking through a statute or a decision and you would look at 7 different legal questions and determine that some are correctness, some are reasonableness. In our view, it's reasonableness, unless one of the correctness categories applies, or, of course, unless there's a statutory appeal clause, but that was dealt with in my colleague's submission. So segmentation would only apply to the extent that there's a necessary correctness category, like in Saguenay, for example, where the question of state religious neutrality was decided on a correctness standard.
So that the issue isn't entirely left out of these proceedings, which have been extensive. Procedural fairness.
Yes.
Are you suggesting that this consideration, if I can put it that way, of standard of review, leave procedural fairness alone as it is now set out in the jurisprudence?
What we suggest is that the Baker framework is adequate, and that it doesn't really fit well within the standard of review framework that we propose, and it's a little bit like the analysis of proportionality for the charter. There's deference already built into the framework, so we don't need to start talking about double deference or no deference. It's deference built into a framework that's applied by courts.
One last question by Justice Kirkitson.
Oh, sorry, may I?
Well, I just wanted to be clear on your position. This is not a closed list, you say, because the rule of law imperatives may be found to justify another category. But I want to be sure I understand your position about contextual factors.
Contextual factors in the reasonableness analysis?
No, in terms of creating new categories of correctness.
So the new categories of correctness, in our view, would need to be based on the rule of law imperatives that we've identified.
That's what I thought you meant. I just wanted to be clear.
Yeah.
Thank you.
You said that there's, under the rubric of reasonableness, there's an answer that says there's only one answer here. How is that different than disguised correctness?
Well, I think that's obviously one of the toughest parts of the reasonableness analysis, but I don't think we can exclude the possibility that there will only be one reasonable answer to certain questions. How do we get there? Obviously, I think you start with the reasons. You first need to determine that the reasons that have been given lead to an unreasonable decision, and then it may be that in that analysis, if there are really only 2 options, by determining that one of them is unreasonable, well, de facto, the other one becomes the only reasonable option.
Perhaps we could ask to Professor Jutra the example that he gives to his class as to what statutory interpretation has ever led to one and only reasonable interpretation.
You may want to conclude now.
I will conclude. Thank you. So, as my colleague mentioned, in its result, our framework in its methodology might not look that different from Dunsmuir, because we're talking about quite a base of deference with categories of non-deferential review. But we did not approach this with any particular result in mind. We did not, as my colleague said, set out to redistribute the Halloween candy. We really started from first principles, and this is where it led us. We hope it's been helpful. But regardless of whether you agree with what we've proposed, one thing is clear. If court does not articulate and come to some kind of shared view of the principles underlying the framework's not going to last. So in our view, respect for institutional design within the limits of the constitutional design, including the Charter, provides a framework that is stable and principled and gives proper respect to administrative justice and to individual rights. Thank you.